Good evening. We are here live every Tuesday from 5 to 6 p.m. Central Time from Houston, Texas. Along with me is my business partner, Reddy Neumann. What do we have today?
All right, we want to talk about what immigration has access to on your electronic devices. Can they look at your WhatsApp? Can they look at your emails, your photos? When you are traveling into the United States, what can they legally do? What is your recourse if they're trying to do that? We also wanted to talk about 221G, administrative processing. We're still seeing consulates delaying visa stamping, saying that they need to continue processing. Sometimes they ask for additional documents, sometimes they don't, but it's just a never-ending process. And so what's the solution to that? No one can stay waiting for months on end without any kind of resolution. We also have a new letter from USCIS. It's issued to the AILA Benefits Policy Committee, where originally AILA had asked a series of questions to USCIS about different issues that have come up with employment-based AOS, adjustment of status processing, since basically October 2020 and all of the different debacles and hurdles we've had with that. So they gave us some answers. This is coming from the director of USCIS. But some of the answers are just not making any sense and just creating more work. USCIS still hasn't figured it out. They're just on Mars. And then lastly, we have a new Biden immigration policy that is for certain countries to get parole into the U.S. Coming in by air. They have the ability to be sponsored by people who are in the U.S., so that they don't have to do the dangerous border crossing and that sort of thing. But that's still leaving legal immigrants out to dry with no solutions, no changes, even though they followed all of the rules. So going back to the original topic, can immigration just go through my phone and look at my WhatsApp and pictures and emails?
Absolutely. If you have been using computer devices for all these years, they do have access to it. And especially for the people that are traveling from the airport, Emily, they do have much more access than doing. And when it comes to the non-immigrant people who are coming on H1Bs, H4, F1s, and B1, B2s, and other visas, though, they can refuse the person if they do not allow them to access. For example, if a B2 person is coming on a B2 person is coming, and the CBP official asks, "Can I open your cell phone?" And if the individual says no, they may be denied entry into the United States. And we see very often people getting deported, sometimes maybe for valid reasons, but sometimes for very vague reasons. It's because of improper communication, the wordings that they see in the WhatsApp application is different. I've seen in one of the person, Emily, where the person got deported, where this gentleman actually went to Los Angeles, and there was a grocery store, and there were some pictures with the grocery store, and the person was asking which shift, when does the shift start? I will come at that shift. And this guy went there at the shift and got deported. But actually, this gentleman was actually going there to buy the store. And he was trying to look into the store to see at that point of time how the store demand is when the guy, which is legal for a H1B person, to buy a grocery store is perfectly legal, but they construed as if you're working there. He was making $200,000 salary. He's not going to work as a $15. He's an employment. No, they didn't listen to anything. I see that you're working in a grocery store and you're not authorized to work in a grocery store. We're going to deport that. There are instances. Today I had a consultation with just a little bit of miscommunication who is picking for her, which her husband was picking for her. And she said, I don't have anybody in the United States. And that was a reason for them to, then they went into the cell phone, look, you have your husband here, and they deported her. So sometimes probably people are not aware what to speak, what not to speak. And sometimes, I've seen them, people who are on student visa, who are working in grocery store, who are working in liquor stores, and there are pictures there, there are shifts there is money trial saying that they work with the gas stations or the liquor store, and they're coming into the country, and since they access the WhatsApp application, then they would be deported. Yeah, probably some of them are properly deported, some of them are not properly deported. I've had situations where in the WhatsApp though, there's a message that for this particular girl, there was a proxy that took the interview. They looked into it and they deported her. I have had situations where the person had faked resume that was there in the laptop, in the emails, and based on that, even though the email was never sent, though it was prepared, it was there in the outbox, which was never sent to anybody, they still deported those people. So what's the solution, Emily?
Yeah, when you're coming into the country, you're wanting to come in, and they're basically telling you, give us your passcode to your phone or we're not going to let you in. So you can choose to withdraw your application and leave if you don't want to open your phone. Otherwise, you've got to open your phone for them and let them access everything if you want to be let in. So you may consider, not having your phone with you as you're coming into the country.
Or if you think so, there is
deleting
some
apps and things on your phone.
And then sometimes maybe have your friend review or your wife review, your spouse review to see if there is any controversial thing. Search with the, work is one of the words though, that proxy, resume. These are the words you can search in the WhatsApp application to see if anything doubtful pops up there. And if you have some doubts about it, you may want to consult a lawyer to speak with the person. What should I answer? What is the best thing to do? What are the airports to avoid? I mean, one of the worst airport is Chicago airport. Every week I get one consultation. Oops, my wife is deported, my cousin is deported, my whoever is deported. It just keeps going on though. Some of the airports are very strict in those things, and they're very vague in deporting the people too. They don't give the opportunity to give an explanation. Sometimes, one time they were about to deport a person, Emily, where this person was working in Chicago. He was actually filed for H1B with end client A, which was in Chicago. And then he was actually working with end client B in Chicago. And the officer says, oh, you require to have an amendment. And finally, at the very end stage though, it was derailed. The next officer took over. It took like after 26 hours of detention, the next officer said, no, this person is allowed to work, and was let go in. But there are situations the officer just let them go, deported, just because he is working with a different client, even though they are legally entitled to do so because it is within the same MSA and a similar job. So proper communication is very important, and I think so that the Chicago CBP team need to be trained on what H1Bs are, when they can work, when they cannot work, and what are the positions where they can work. It's also a lot of confusion in Chicago office, and a couple of Seattle, Boston are the other airports that I would recommend people to avoid. Anything else, Emily, before we go to the next?
I think we can go to the next topic. So 221Gs, we're still seeing these issued by consulates for administrative processing. They say it's technically a refusal. They cannot issue the visa at this time because they need to continue to look into it. Sometimes they're contacting the end client to verify employment. Sometimes they're looking into the company. Sometimes they're looking into the employee. They have all kinds of reasons, but they never give you the actual reason. Sometimes they do ask for documents. Sometimes they ask for documents that they shouldn't be asking for. We have a settled law now, thanks to the IT serve litigation, that they shouldn't be asking for end client letters and contracts and purchase orders and those sorts of things, but they're still doing it. And then they sit on the case for 8, 9, 10 months. In the meantime, you lose the job.
What's the solution?
So litigation is the solution right now. It doesn't help to contact the consulate, to contact your senator. Nothing helps. You can't contact USCIS. This is Department of State, so it's a different agency. But litigation is working. Of course, we can't say it will always be 100% successful in every case. We can never guarantee that. But what we are seeing for people who've been receiving these extreme vetting forms to fill out their address and employment history for the last 10 years, and then they sit on the application filing a lawsuit for the unlawful delay. Within a couple of weeks, they got their visa stamp and were able to enter the country. For an F1 student who was delayed with no explanation at all, got the stamp within a couple of weeks and was in the US. So we're seeing time and time again that filing the lawsuit is working. It is causing them to realize that this is an unlawful delay. They're hurrying up, approving the visa, and then asking us to withdraw the lawsuit. So if you want to explore that, if you're facing that situation or know someone who is, Stephen Brown is the attorney in our office who's handling those cases, so you can reach him directly or set up a consultation with him by going to rnlawgroup.com.
With regards to the USCIS director living in the dream, I think so that they are from Mars. USCIS is from Mars, not from Earth. 50 months to adjudicate a 485 application? Why? I mean, don't they understand if they adjudicate the 485 application, they don't have to extend the EAD in advance parole?
Right, which they're doing for free. Now, of course, they're going to stop that, but those people that are already filed and are in the system will keep getting it for free, even with this new fee going up.
But won't it be prudent for them that, hey, instead of I will spend 1 hour, or instead of spending half an hour every 3 months, every 6 months, instead of spending half an hour, why can't I spend 1 hour and decide the case when the final action dates are current? Now they are separating EAD and advanced parole for stupid reasons. For what? Why are you adjudicating EAD and advanced parole and taking more time to adjudicate it? Then what happens? EAD and advanced parole cannot be filed together because you have to file within the 6 months. Then you have to approve the EAD again, you have to approve the advanced parole again. This is telling where is your nose instead of pointing it like this. And maybe going all the way there, I don't know, my hand doesn't come. That's how the USCIS is doing the things. It's very ridiculous to have the EAD and advanced parole approved at different times. And now what are the comments that they said on the letter that they have written?
Yeah, so one of the things that they raised is the issue with dependents who didn't get the approval of the green card when the main applicant did. And they basically say there's nothing we could do about it. It just happened because at the time we were ready to adjudicate. The dependent needed something further. We had to send an RFE or whatever. So they approved the main applicant, not the dependent. And now you still get the benefit of having a pending 485. You can have your EAD renewed. You can have your AP renew, and life is great. You don't have to worry about anything if you're in that situation. I mean, that's just not true. I mean, imagine now you've got multiple people with different statuses. You might have a green card holder husband, an AOS pending wife, and a U.S. citizen kid. Imagine trying to travel.
Yeah.
Like, what documents do you need?
3 different lines.
Yeah. So no, that's not.
And these people end up filing the F2A application.
Creating more work.
More work for them.
And so Ayla is suggesting that maybe they should expedite these F2A applications since it's their delay that caused it in the first place. And they're saying that they will consider to do that, but you can guarantee that's not going to happen. Then we move on to these transfer of underlying basis. So you all know, filed the downgrade in 2020 for EB3,
then
upgraded to EB2, and now EB3 is ahead. So some people want to go back to EB3. So what do they want us to do? File another supplement J, another form they have to adjudicate.
They already have it. They already have the I-140 approval of EB2. They have I-140 approval of EB3. Why don't they just adjudicate this application instead of making us file the EB3 downgrade application again with the transfer of underlying, and they're not even charging any money for this, though, which is stupid.
Just creating more work for themselves again.
With no money to them.
Yeah. They're saying that for cases that have been transferred to the local office and then the date retrogressed, that their plan is to transfer all of those files back to the National Benefits Center.
And when the priority date becomes current, they have to transfer back to the local office. Oh, the nose is not like this. It could be somewhere else. Something.
Yeah.
It's my nose is in the Mars. Okay, I forgot that. USCIS is Mars.
Yeah, and then they say, just so you know, once your date does become current again, we are on top of it. We're just going to adjudicate it. We might have to ask for a new medical. We might have to get updated documents, but we are keeping track of it and we will process it. Well, you know what? They aren't even processing the ones that are current now. They're not tracking this.
Yeah.
They weren't even doing first in, first out before. So I don't know what they're saying, that they are on top of things and they know when the date becomes current again and they will process them right away. And then lastly, they were asked about these erroneous adjustment of status approvals, people getting approved in the wrong category, people getting approved where the spouse, the derivative spouse gets approved, but the main applicant didn't. All kinds of different things were going wrong with these. And their suggestion is if you think that you have an incorrect approval, to call the 1-800 contact center or customer service number. I can guarantee you, if you call that number, you're not going to get the help that you need. We've had people being told completely wrong information on that number. You sit on hold forever. That's just not the proper way to do this. So unfortunately, I think that the director thinks these things sound good, but in practice, they're just creating more work for themselves without getting additional filing fees.
But what is getting attention, what I see, Emily, is that if the priority date is correct now, if people have been waiting for the green card for more than 1 year, if you file a writ of mandamus with the federal court, that is a better way rather than contacting. Because if you contact the ombudsman, if you contact the senator, they'll just point out the processing time is 50.5 months. Guess what?
50, not 15, but 50 months.
Yeah, 50 months, 0.5 months. So it's 50 months. Let's take it 50. Okay, we'll give the discretion of the 15 days. 15 months. Now, Emily, 2 years back, it was 13 months. And from past 2 years, it moved from 13 months to 50 months. And then what is going to happen in the next 3 years? They're going to move forward? I don't know. But if your final action date is current, though, I strongly recommend, though, and your application has been waiting, you've filed a 485 for more than 1 year, though, we strongly recommend to file a writ of mandamus. What is writ of mandamus is that, hey, USCIS, you said you're going to adjudicate these applications in 6 months. Why are you taking this much? Adjudicate my application. That's simply the words we are going to file the federal court. And typically, the USCIS doesn't want to face the judge, though, and they may adjudicate your application faster. Now, this is not a guarantee, but we have seen, it is a better source for you rather than keep waiting for the 50 months and it's not there that after 50 months they're going to give it to you. They may postpone the date. So I would strongly recommend that you should consider the writ of mandamus.
All right, last up. So what is the deal with the Biden administration, legal immigration versus undocumented immigration?
Okay.
Why are we focusing on undocumented?
Correct me if I'm telling anything wrong. So some of these people, not all the people of those countries, guys, but some of the people from Guatemala or Honduras, so they want to come into United States. They want to jump the wall and come into United States and stay here illegally. Some of them. So they come in caravans, like hundreds of people. They take a trekking from whatever countries they are from. They come to Mexico, and Mexico they come like a caravan. It's like a big band, everything coming together. They come in a caravan, and all of a sudden when they come to the border, it's very hard for the CBP people because let's say there are 50 people, there are thousands of people coming in. They can't handle, and people pour into the country, and that becomes a mess for the administration. So to resolve that issue, what they're telling is that, hey guys, you don't have to come illegally. You can actually petition for a parole document while you're in the country. You can come into this country. I mean, this is like they're putting a threat on the border. Hey, either you allow us illegally or you allow us something legally illegally. Because parole practically is not an entry into the United States, though technically speaking about. So it still is not a good thing for the administration to do, according to me. Now, let's leave the topic aside of the people who are trying to come into United States illegally, and these people are making them more easier to come illegally. That's exactly a parole. Now, this is not advanced parole, guys. This is called parole. Parole is given when you're outside the country, when you're not eligible for A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U visa. In all these visas, you're not eligible for it. You're not eligible for the green card, okay? Then some of the times you are being paroled. For example, Ukraine people, they are helpless people. They need to come into, they are not eligible for asylum because when your country is at war, you're supposed to fight, not run away from the country. So they're not eligible for asylum, Ukraine people. So for the humanitarian considerations, yes, Ukrainian people are allowed. So that's what the parole is for. That means that if you're not eligible for A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U visas, and you're not eligible for the green card, then you can request for the parole. So that's what these people are. People who are not eligible for any of the visas, they are allowed to come in if a relative petitions for them. Is that what?
Yeah, it doesn't even have to be a relative.
Yeah,
Anyway.
somebody petitions for them. And this is not a I-130 relative petition. Somebody petitions for them, and they will, and petitions for the parole, they are going to come into the country.
And can work.
They can work legally. Legally or illegally, which is,
legally,
their entry technically is not legal, but the EAD is given to them, so we don't know whether it's legal or
and
illegal.
no restrictions on that EAD.
They can work
for
in
anyone.
Microsoft CEO, or they can be flipping a burger at McDonald's. While the people who are trying to get the non-immigrant visas like H1, which is already approved, H4, F1, and B2, which they're eligible for because they want to come and visit Disney or probably visit their relatives, they're getting delayed. Delayed, and sometimes, as you said, 221Gs were being issued, and some of the approvals are taking a long period of time. And you know that they are counting the family members in the employment-based immigration. They have wasted 60,000 green cards while this administration came into the power. And they're doing all these kind of things for the legal people. For the unlawfully and trying to enter into the country, they have given a very good path for them to come into this country. That's strange to me that this administration focuses not to encourage the legal immigration, but to discourage the legal immigration, at the same time increasing the illegal immigration, which is very, very bad for this administration. So unless we point out that, look, first you need to resolve the legal immigration problems before you go to the unlawfully coming into the United States people who are threatening the border, who are not willing to comply with the rules of this country, at the same time neglecting the people who are wanting to come legally in the United States, wanting to stay in the United States legally, wanting to pay taxes and comply with every rules and regulations they have. Not only that, Emily, they want the people who are legally trying to come into the United States to pay for them, for the people who are trying to come illegally. The proposal for the filing fees increases says that the people, most of our clients, will be taking the burden of the expenditure that is going to be incurring in facilitating the people who are trying to come illegally into the United States. That's what the fee structure is. That's what they want to do. And that's what is being proposed. And Mr. Stephen Brown has put a video on that today with Reddy Neumann PC. You can watch the video on that, but please write a letter to these people not to increase the fees for the non-immigrant visa people, only to benefit the illegal people. I mean, this is not fair under any circumstances to take the burden on that. They're going to add the filing fees for the EAD and Advanced Parole for the AOS. Why? Because they want to benefit the people who are trying to come illegal people. They want to increase the H1B fees. Why? They want to benefit these illegal people. So what will happen? The legal immigration is going to be overburdened. The people, employers who want to sponsor have to take the more burden to take these illegal people, and not good for our economy, not good for the country. So we want you to protest these things, and we'll keep on drafting the letters for you. Mr. Stephen Brown has already drafted, so please follow his directions, which was, we put a video before. We'll go to questions and answers. Unless you have any.
Nope, that's everything there. Srinivas says his son aged out, is a documented dreamer, and is now on F1 working on OPT, and wants to know if he can go for a 5-day cruise to Mexico using automatic visa revalidation, because he does not have the F1 stamp and his prior H4 from being a child of an H1B holder has expired. So automatic visa revalidation does work for someone who's in F1 status to travel to Canada, Mexico, or certain Caribbean islands.
For F1
For
visa.
F1.
F1. So
Right.
this is where one of the person got confused. The automatic revalidation for Caribbean islands, Mexico, and Canada will work for F1. When it comes to the H1 and H4, only Mexico and Canada, not for the Caribbean islands.
Right. And so you need to make sure that there's a valid I-20, that you have the old expired H4, proof of the change of status to F1, and then verify where all this cruise is going. It can only go to the locations that are in those Caribbean islands or Mexico. So verify all of that. But assuming it's only Mexico and you have all of that documentation, yes, automatic revalidation does work for that.
Sai Krishna has this question from Facebook. My green card interview is scheduled, but my date is not current. What to expect? Yeah, even if your date is not current, they do interview people sometimes. We want you to be prepared. Have a mock interview done by your lawyer if your lawyer is not willing to do it. Have some other lawyer have a consultation, do the mock interview done. That will be much better. Nothing. They're going to ask you questions about your employment. How did you get the employment? And they're going to ask questions on the 485. Have you been deported? Have you been any criminal charges? Whether you are maintaining the legal status continuously from your last interview to right now. The routine questions. We put a video just for that, like it's about 15 minutes video called AOS interview, Reddy Neumann. Type it on the YouTube. You will have that one. It's about 10-15 minutes video. We want you to watch it. We describe from every step. Will you be sitting on the left side or right side? We give various directions. We know which place you will be sitting. To that extent we have gone. Please watch that video.
Why are they interviewing people with the date not current, sending medical RFEs when the date's not current?
One thing, Emily, is that let's say, for example, if the person is being illegally in the United States and filed a 485 application, they don't have time to review it. They want to look into if this guy is still eligible to be getting the green card. Otherwise, they want to deny the green card. They don't want to give the benefits of the EAD and advanced parole. And sometimes, when the interview is done, though, Emily, when the priority date becomes current, it may be easier for the officer to approve the interview. So I'm okay if they're interviewing.
All right. Ram says he currently holds an H1B, has an approved I-140, is working for an IT company. He got an offer from a nonprofit organization. He wants to know if he transfers over to the nonprofit, will he be able to go back to a for-profit employer in the future on H1B? Because if you have an H1B that is cap exempt because it's a nonprofit employer or affiliated with the university, you have to go through the lottery if you want to switch from cap exempt to cap subject. But in your case, you've already been counted in the cap by your current H1B, so you can switch from for-profit to nonprofit back to for-profit without going through the lottery again.
Why is my wages not getting approved? It's been 1 year, still no response from USCIS. What is my next step? It feels like I'm in the dark out here. What you mean to say is no response from USCIS. You mean to say Department of Labor you're speaking about, I'm assuming. Because prevailing wages for the green card application are being filed with the Department of Labor, not with the USCIS. 1 year definitely is a long time. Something is wrong somewhere. So we haven't seen a delay of 1 year for the prevailing wages.
Ram says, my H4 EAD is expiring in January. I'm not working right now. Can I still file for the H4 EAD renewal and file it later without any issues? So yeah, you don't have to constantly maintain the H4 EAD if you're not working. That's fine to file it later. I would just caution you that you may want to consider filing it on time anyways, because by filing it on time, you are improving your likelihood that you'll eventually qualify for the automatic EAD renewal. Because what happens a lot of times if you don't file that extension and then you end up getting the great job offer and decide to go back to work, and guess what? Now you have to wait till your new EAD gets approved, which can take months and months and months, versus had you filed that timely extension and gotten the new H4 I-94 that extends beyond that time, you can start working based on the pending extension. So no, you don't have to file it, but you may want to consider it just as a backup plan, because you never know when you're going to get that job opportunity you may want.
Money has this question. She's naming me perfectly. Security check on the H1B petition. Will premier processing help to speed up? Money, I want you to do one thing. Definitely do the premium processing. If it helps, we're good. Don't worry about it. If it doesn't help, that's saying that it's a security check, we are not going to adjudicate the application. I want you to file a writ of mandamus. Here is the reason. Once they say security check, you go to ombudsman, security check, no. You go to congressman, security check, no. So what they mean by security check when they tell the congressman is that you could be Al-Qaeda, okay? You could be ISIS, are those terrorists. Now, of course, if you are that person, though, the first thing, I don't want you to be living freely in this country. I want you to be in the jail or probably kicked out of the country, money. Of course you are not. So this is where the question, they don't release the information to us and they keep telling it's a security check. When we file a court case though, this is what we tell the USCIS. Look, if you are telling my guy has a security threat, okay, show it to the judge. You don't have to show it to me. Let the judge decide. Let's say, for example, if you are an ISIS, you have gone to Syria and fought in favor of ISIS, they should put you in jail. I want you to put you in jail. Money, I want you. But if it's not, then you should not be in the security check. Sometimes the USCIS will get confused. Most of the times, or I would say sometimes. You know, one of my friends' name is Murali, and happens to be that his date of birth is matching with some bad terrorist. And that bad terrorist name is Ali, A-L-I. And this guy's name is Murali. Last name is Murali. It ends with A-L-I. Now, they say that this guy is a security threat because he's Ali of that date of birth. Well, if that, you check him very carefully. Go to his home. Find it out if that guy is the guy. If this guy is the Ali that fought in the ISIS, you put this guy in jail. Otherwise, you release all the security checks for my client. And they did release it. Because this guy is not the same Ali with the same date of birth. No, this guy is not the same. So I would recommend first to do the premium processing. If it works, you're good. If it's not, I want you to do the writ of mandamus, because otherwise they may go this one on the I-140, they may do this in everywhere.
Austin asks, what happens to my H1 extension that's pending if I travel and return to the U.S. on the AP, assuming that when I'm coming back, my H1 extension is still pending? So you'll re-enter on the AP, get an I-94 that's valid usually for 1 year based on that entry on AP. Your H1 will continue to be processed. It'll still be approved. It'll come with a new I-94, but getting that does not put you back in H1 status. So if you're wanting to get back in H1 status after that H1 extension is approved, if you have the valid AP still, you can go out and come back in on H1B. You could use automatic revalidation for that by traveling to Canada or Mexico, assuming you don't have the H1B visa stamp. That would be an option if you wanted to get back into H1B, but it will still be processed.
Anand from Facebook has this question. Can non-profit organization file Supplement J? And can GCEAD holder work for a non-profit organization? Absolutely yes. A non-profit organization can file a 485J supplement and you can work for the non-profit organization as long as it's in the same profession. So if it's a software profession and you go to the non-profit, you're working in software profession, they can file a 485J supplement, you are in good shape. Okay, go ahead.
Mithun wants to know what is the impact on a pending H4 EAD if the H4 holder travels while it's pending. Both the H1 and H4 are already approved, and the visa stamp is expired for the H1 and H4. So the EAD itself will still be processed. As long as you were in the U.S. at the time of filing and your H4 extension is approved, the EAD will be approved, even if you left while it was pending and came back on the new H4 visa stamp. No issues at all.
Takeshwar Roy has this question. My kid is becoming age out next year. And if F1 is showing 18.5 months, thanks to USCIS, what are my options? Takeshwar, you can have your child file for F1 visa. Once the F1 visa receipt notice comes to you, Even if he ages out, you don't need to file any other application. He can continue going to school, okay, and keep updating the I-20, but he doesn't have to file. Previously, we had to file a bridge application called a B2 application. Sometimes we had to file like 3-4 B2 application. Thanks. USCIS has done some better things though. I can't say that they are completely baseless, but sometimes they did. They made a provision right now that once you file F1, you don't have to file any bridge application. You, even after your child ages out, you can wait for the F1 approval. He's in good shape.
Momo applied for the 485 in March of 2022, so almost a year ago. Still has not received an EAD and is a physical therapist. Filed an expedite request for the EAD under the healthcare worker expedite criteria. That was denied. H1B is
Why?
valid.
Physical therapist is not a medical worker?
Right. H1B is valid till 2024. Can I sue? Absolutely. This sounds like a perfect case for an interim benefits delay case. Stephen Brown in our office handles those all the time, so you can contact him about that process.
Very good
that
case.
one's a pretty
easy and good case.
Yeah. Ridiculous.
Even though you have an H1B, maybe you want to do extra jobs. I mean, a physical therapist typically do multiple jobs, multiple locations. That doesn't allow you to do multiple jobs on a H1B. Because my wife is a physical therapist, I know how it works out.
CP says, we have EAD and AP. I am on H1B. My wife is on H4 and wants to know if his wife works on the EAD, will she be out of H4 status or will he be out of H1B status? So the wife who's on H4, if she uses the green card EAD, that does take her out of H4 status, but it does not impact your H1B. On the other side, if you were on H1B and you use the EAD, it takes you both out of H1 and H4 status. But a dependent using the EAD does not impact the main applicant status.
Senthil filed 485 in EB2 and he doesn't have an I-140 in EB3. So what are his options? His company is not willing to file for EB3 even though he's willing to pay the money. Well, then you have to move out of the company or find a company while you're working with this company to have an EB3 labor, but the new company has to file a labor and I-140 again. So that's definitely going to take 2 years process for you. Is it worth for you or not? It's going to be very tough. I can't tell that because I cannot predict the priority dates movement perfectly. So, but yeah, if your company doesn't want to do it, maybe you need to find another company that can do it.
Mackie says, my H1 transfer is filed in premium processing and I got the receipt number but haven't joined the new employer. Can my dependent use that receipt number to submit their DS-160 and book the visa stamping appointment? Yes, I don't see a problem with that as long as by the time they actually go for their visa stamping interview or the drop box, the H1 transfer is approved and you've joined that company.
Vinod Kumar, my advanced parole card denied because I traveled outside the country. Can I reapply advanced parole? Since my date is not current, please suggest. Absolutely, you can reapply for advanced parole. No problem, none whatsoever at all. Krishna has this question: can dependent be on AOS EAD while without H4 extension while primary continue to be working on H1B? Yes, absolutely. You can be an H1B. Your dependent can be on EAD. In fact, perfect. I was that. I became an immigration lawyer while I was a dependent on H4 on the AOS EAD. I even worked as an immigration lawyer on the adjustment of status EAD. I did.
Kamlesh has an EB1C, I-140, and 485 filed in September 2021. Both the I-140 and the 485 are still pending, and he wants to know, since the 485 has been pending for a lawsuit for a year, is a lawsuit a good idea since the I-140 is still pending? So we definitely need that I-140 approval. We may consider filing a lawsuit for the I-140 delay as well. We would want to look into that case, make sure it's a strong case, but it's possible. But we do recommend that either filing the lawsuit for both or get the I-140 approved first and then file.
Ganesh and Venkateshan's question: the news in 2014 about EAD for approved irrespective of the priority date. Was that a real or just another rumor? It definitely was not a rumor, Ganesh. There were definitely concrete evidence at that point of time when we released that information, um, that the people who have an I-140 approval, they will grant a EAD for all the people at that point of time. The rumor was leaked. Now, as it went on, um, they watered it down to what we call nowadays as compelling circumstances. We made a video on it that they did after the rumor was there, they did allow the people to get an EAD for whoever has the I-140 approval. But the problem with that is that they only limited under compelling circumstances, and the EAD is only valid for 1 year. Every time you have to extend it. And we have made a video on compelling circumstances. You watch it. It's been there. It's been there about 2 weeks ago. We put it up. You can watch it. But normally for people who are in H1B and H4, we do not suggest compelling circumstances EAD. Only if they lose their jobs and if they have no other alternatives like H4 or no other better alternatives, then we tell them to use the compelling circumstances EAD. But you're right. At the time when the rumor was released, we thought that everybody with I-140 will be allowed to get will be allowed to get an EAD. Now, do they actually do these kind of things in immigration? Have we seen any of those things done by this administration or previous administration? People getting EADs just like that? Yes. There are 1 million people who are unlawfully present in this country, who entered as a child under 15 years of age. They got an EAD. And there is also called TPS. That means that if you are from Nepal, you came into this country before a certain year, they all got the EAD because when they got the earthquake. Can they do for I-140? Yes, they can.
Yeah, just like the H4 EAD.
Yeah, just like H4 EAD, they can allow. They can allow. I wish this government will take into consideration and probably give an I-140 EAD rather than have you guys pay the money for the people who wants to jump the wall and come into the United States. Yeah, they should benefit people like Ganeshan, who is paying the taxes and willing to pay the taxes and willing to remain in the United States legally until he gets a green card, or if he doesn't, he wants to get out of the country. And we want people like Ganeshan to be promoted rather than the other people.
Krishna says, what are the consequences if the Indian passport is not renewed by the expiration date while staying in the U.S.? So for a non-immigrant status, like an H1 or H4 holder, L1, L2, part of being in lawful stay in the U.S. does require you to always have a valid passport. So if your passport expires while you're in the U.S., USCIS could say you're not maintaining lawful non-immigrant status, or you're violating your status. So you want to make sure that you apply for that renewal before the expiration date. If the renewal gets delayed and doesn't come in on time, at least you can show that you tried to get it properly. The only time that becomes a real problem is if you happen to be filing your extension at the time when your passport has expired and you don't have the new passport yet. In that case, you could get a denial of the extension saying you were failing to maintain status at the time of filing because of the passport expiration. So make sure you time any filing with USCIS around that passport expiration so you don't fall into that situation.
Kelby 26 asks this question. Since the rest of the world EB2 is not current, can my employer file a EB3 for me instead? I have a PhD and work in quite technical. Yeah, they can. If you're eligible for EB2, it is automatically eligible for EB3. This is simply, how do we document EB3? How do we get an EB3 approval? It's very simple. It's if you give a task to a lawyer, prove that a billionaire is a millionaire. How hard is it for a lawyer to prove a billionaire is a millionaire? Yes, every billionaire is an automatically a millionaire. I guarantee that. Believe me, trust me on that, okay? Now, every millionaire is not a billionaire, that's for sure, but every billionaire is a millionaire. So in your case, you are a billionaire because of the labor certification and your qualification. For me to prove that you're a millionaire is very, very easy. You may be $100 billion because you have a PhD. You may have $100 billion, but you still are classified to be. If I have to classify you as a millionaire to get a ticket somewhere, I will. There's nothing illegal in it.
Vinod's AP was denied because he traveled out of the country. He wants to know if he can reapply for it now since his priority date is not current and his AOS is still pending. Yeah, so to file the AP, you have to be physically present in the U.S. and have the 485 pending. So if you've returned back, your trip is over and you're not going to be traveling during the filing of the second application, yes, you can just refile it. The denial has no negative impact on the refiled application.
Would you recommend filing an EB2 under premium processing versus regular processing? First thing, Vaibhav, if this is a first I-140, I definitely want you to file in premium processing. Why? Because there are a couple of reasons. One, if you have an I-140 approval, after 6 months, if you leave the company, you get the I-140 to keep it. If you have an I-140 approval, you leave after 6 months, you get to keep the priority date, you get to extend the H1B, you're supposed to get the H4 EAD. What if the I-140 takes a long time to get the approval and then you lose the job and they withdraw the I-140, you're screwed up. So for all reasons, if this is the first I-140, definitely premium processing. Now, if your priority date is current, definitely premium processing. If this is a second I-140, you had an I-140 in 2017, this is the second I-140 you're filing with the company, nah, you don't need to do premium processing because you're already covered by the 2017 priority date. I would not if I were you.
Arun from Facebook says his wife has a valid H4 until March 2024 with the visa stamp in her passport, but her H4 EAD is expiring in April 2023, and he wants to know if she can file for the H4 EAD extension and continue to work based on the receipt number. So based on this situation, yes, she does qualify for the 540-day automatic EAD extension because her H4 currently is already valid beyond the validity date of her current EAD. So as long as she files the EAD renewal before it expires, she can show that receipt notice, the expired EAD card, and her H4 I-94 that's valid beyond April 2023 to prove that she qualifies for that extension. And he also asked, will USCIS to continue to extend that 540-day auto extension beyond October 2023? I think that will depend on filing volumes and what processing times are by that point, if they're able to get things under control, which as of right now, I don't have high hopes for that.
Emily, didn't you recall that when we wrote the letters to the USCIS to adjudicate the 280,000 green cards, the USCIS came a very extensive response that their target is to approve the 485 in 6 months.
Mm-hmm.
And 6 months later on, that
50 months?
it moved from 2 years, 2 years to 2 years to 4 years. Mm-hmm. So if they continue doing that, I'm definitely sure that they are going to extend the 540 day rule. Because otherwise there will be a lot of lawsuits filed against the USCIS because of writ of mandamus. People are going to lose their jobs unless they have the 540 day rule. So we are expecting those USCIS to extend beyond October 2020. Yeah, really, what happened to the 6 months 485 adjudication?
Yeah, I forgot about that.
Yeah. Now they come up with this rule, 15 months in Texas Service Center. God knows.
Krishna is on H1B with an approved I-140, and his wife is on H4 and wants to study and wants to know if there's a disadvantage if she changes status from F to F1 from H4. Well, I think one of them is the cost, the tuition. You're likely to be paying international student tuition on F1 versus H4. You might get local resident tuition.
At least I got when I was in H4.
Yeah.
I went to LLM here, yes.
Yeah, so to me, there's more advantages of staying on H4 except for you don't get the OPT, but you have an approved I-140, so you have an H4 EAD. So what do you need the F1 for at all? I don't see any reason to an F1.
In fact, for traveling is going to be a big problem for them to come back in F1 because I just got one person deported today at a consultation. He was coming here. They asked a question, are you going to stay with your husband? Yes. Then you're not eligible for F1, then got denied. So definitely, if you have the H4 EAD option, I don't see any reason whatsoever at all to move to F1. And believe me, there are ways of hacking the 540-day rule, guys, where you can go to Mexico and extend the H4. It's an easy way of hacking. Previously, we had fear that the H4 EAD was not getting approved in the proper timing. Now we don't have that fear. So I don't see any reason. In fact, when I got an opportunity, Emily, when I was coming from India, I got an I-20. I chose to come on H4 instead of coming on F1. Not only that, after coming here, I went to LLM. I went to school here. I choose to stay on the H4 instead of actually going to F1 because of the because by the time I was graduating, I was about to get the EAD anyway. That's one of the reasons. But fees, that's a lot of fees for me to pay if I'm an F1 visa, to pay 3 times more fees than the normal person paid.
Surya has a valid I-797 H1B until 2025. The visa stamp is valid till 2022. He traveled last year and got the I-94 cut short to September 2023 because the passport was expiring. And he wants to know if there's any issue with the status now. Well, number one, thank you for checking this now and not after September 2023. You've done the right thing seeing that it was cut short. When you see this happen before the I-94 expires, you can fix it. So you don't have to do anything today. Your status is fine right now. But before, so your end date right now is not August 2025. It is September 2023. So once you have your passport renewed before September 2023, you can go out and come back in to get that extended I-94 till 2025. Or if you don't want to travel, you can have your employer file an H1B extension by September 2023 to get that extended time to 2025. So those are your options because you figured it out before it expired. It's very important to take action before that short I-94 expires.
Emily, I have this question from Kwan. I need some help in answering the question. If somebody is on H1B and has an advanced parole and EAD, and if they travel outside the country on advanced parole when they come into United States, do they consider to be an H1B or not? Okay. First, let me answer Kwan. This is the most commonly asked question because we do have a daily conference call. You can come and ask the question there. I will be there, and the link is provided every day. We do conduct daily conference call. We provide the link. This is the most commonly asked question in the past 6 months. First thing is that if you come back in advanced parole, even if the I-94 expires though, unlike the previous guy, in this one, if they say you have been advanced parole, they only give 1 year permit. You still can extend the H1B. You can still transfer the H1B. And you do not have to update the I-9 form. You don't have to update the I-9 form from EAD. So that's what the law says right now. That's what the memo says right now, that you can extend it, you can transfer it. Now you can also don't need to update it, and you don't have to go with the I-94 given online for the advanced parole. Now, here is the question, whether or not you are on advanced parole, whether you are on H1B. Now, some lawyers answer saying that they are on advanced parole. Some lawyers say that it's a H1B. There's a difference of opinion in those things. I think so. You go with advanced parole, right?
Yeah, until the H1B gets approved.
But I believe that it's H1B. There is no way to prove whether she's correct, I am correct. But this is what my argument to Emily is. If you can extend the H1B, if you can transfer the H1B, if you don't have to update the I-9 form with the EAD, I believe he's an H1B. The first thing is I-9. I-9 requires that you need to update the immigration thing. They don't need to update because they can extend the H1B. So I believe it's H1B, but you believe it's advanced parole because it says advanced parole,
Right.
right?
But in most 99% of the cases, it doesn't matter.
It doesn't matter for you.
USCIS never asks that question.
Right.
It never comes
Who
up.
is asking that question whether you are an H1B or advanced parole? Nobody's asking. It's only you guys who are asking us because we are available for you. The immigration is not asking. Nobody is asking you right now. Can you use the EAD to extend your driving license? Yes. Can you use the H1B to extend the driving license? Yes. Can you work beyond? Can you work on H1B? Absolutely. You're perfectly right. So that question is asked, and each lawyer, Emily is telling it's advanced parole. I'm telling H1B. I think so. I'm right. She thinks she is right, but there is no way to judge whether she's right or I'm right because there's no judge outside to judge us right now.
Fanny Kumar's employer filed the 485 with the downgrade to EB3 in 2020. Then he interfiled to get into EB2 in 2022, filed the supplement J. Of course, now the priority date's not current in EB2, but it is current in EB3. He wants to know, is my application under EB3 or EB2? Do I need to downgrade it again? So right now, since you submitted the supplement J, we assume at some point USCIS will look at it and determine whether you could be an EB2 or not. But because you submitted that supplement J, now USCIS is saying if you want to go back to EB3, you've got to submit another supplement J. You can't just withdraw the one that you already submitted to get to EB2. So again, you've submitted 3 supplement Js, you've done 3 times the work, causing USCIS to do 3 times the work. And then EB2 will become current and EB3 will retrogress, and we'll be having the same discussion a year from
now. One question that is coming is, Money has a EAD and advanced parole approved. He has a pending I-485 application. His priority date is not current. He wants to travel to India. Will he have any issues coming back in advanced parole? No, none, zero, nothing. However, I want people to be cautious though. When people are coming into United States on advanced parole, some of the airports don't have the processing units of advanced parole. When you enter into there are lines there. When you go in the line, when you show them I'm coming here on advanced parole, then they will say you wait at the side. Then a CBP officer with a gun will come and will escort you to a small room. This can happen for 50% of the airports it happens. Don't be worried about it. You are not a criminal. You're not a drug guy. They don't have the processing facility there. They will take you to something called soft secondary. That's what we call it as. Even when people get adopted from different South American countries, these American couples bringing these kids also, those little 3 months or 6 months kids that they recently got adopted, these mom and dads are hugging them because they're new kids and all those things, and they're getting into love with the kid. They are also taken to that soft secondary, not because the kid is a criminal or anything. It's just a process that they have to go to. So be prepared for that extra half an hour, but otherwise, no problem, none whatsoever at all for you to come back into the United States.
Chris wants to know why immigration processes your I-130, and then NVC looks at your I-130, and then the embassy or consulate has to interview you over the exact same thing that USCIS and NVC just did. It's so broken. Yeah, there's definitely a lot of redundant things.
Very good question.
Yeah, same thing with H1Bs. USCIS looks at the I-129, and then the Department of State looks at it at the consulate, and then there's the FDNS site visit looking at it again. Yeah.
And the consulate in India re-adjudicate center application where the guy is entering into this one. Well, we call that as a bureaucracy. I mean, what else? The people with common sense don't work for the government, that's what we say. Yeah, it's really, they don't have the common sense. You have it. You have it. You nailed it. But they don't.
Job security, I guess.
Yeah.
Well, I think we are out of time for today. Thank you all for joining us. We'll be back again next week on Tuesday at 5 o'clock. Feel free to join our newsletter by going to rnlawgroup.com. We send that out every Wednesday. And you can also join our daily conference call if you want more questions to be answered. We do that every day.